Appeal, the Queen and Vasyli.
Good morning, Ms. Montgomery.
I think the committee now, I take this Appellant together with Mr. Joanne Buckley. The prosecution respondent is represented by Mr. Thomas Rowe. As I suspect the committee has also gathered, the issue of principle on which this appeal was originally grounded, namely whether as a matter of procedural fairness an appellant in a court of appeal who is ordered to be retried should have the opportunity to be heard before that order is made, is now conceded. And
your solicitors have produced a great volume of material over the last couple of days. In their letter, they didn't condescend to an explanation as to why it was produced so late in the day. So I have to affect, at least, to be stern with you, Ms. Montgomery, about that.
well, I hope your Lordship isn't too stern, because you've received the respondent's note complaining about it before you even received the material.
Oh, no, we're not motivated by the response note.
And we did explain, not to the court, but to the respondents. They chose to give their rejoinder to the court, so you've heard only one hand clapping on this one. Mm-hmm. But it may be I don't need to go there.
No, don't. I just have to register.
No, thank you. Reprimand received and understood. I apologise. I am sorry.
No, don't worry. Benevolence prevails.
Having conceded the issue of principle, the respondent's main argument is that the committee should nevertheless itself order a retrial for reasons that are set out in the respondent's case, and indeed for the reasons expressed by the majority of the Court of Appeal. Firstly, we would observe that the plea to expedition might be more persuasive if they'd conceded the principle back in the Court of Appeal, because the matter could then have been relisted for hearing back in 2017 when the decision was made, rather than coming before your lordships with a rather convoluted history now in 2020. But in addition, that plea to expedition is, we say, founded on two false premises. The first is the proposition that the Privy Council would ever order a retrial of its own motion in a case of this sort. As a matter of practice and principle, we have never traced a case in which the Privy Council has done so. The practice is well established, and I will show you a case that states that as being the matter of invariable practice. It is remitted to the local court. But it's based on principle because it's the local court that's in the best position to assess the multifactorial issues that will arise in deciding whether or not a retrial should be issued. And indeed, one of the reasons that at least one of the items of fresh material that we were going to put before the committee was to point out that there is a live issue about a highly prejudicial television programme that has been made about this case, which the court would have to consider at any hearing.
You're not going to ask us?
No, I don't want you to watch it. No. Indeed, I want to make exactly the opposite point. Mr. Rowe says you should decide to order a retrial here and now. And I say, well, if you're satisfied there's a case to answer, you certainly shouldn't be ordering a retrial, because there will be all sorts of local issues that can only be resolved by a local court of appeal, which has a hearing, looks at the evidence, makes decisions about potential impact on the jury pool in the Bahamas.
Would that not normally be a matter for the trial judge to decide?
No, because obviously the Court of Appeal's jurisdiction in relation to a retrial is to consider whether the interests of justice require it. And obviously it may be that they would say those interests can be met by the judge taking a view on publicity. But there are some cases of publicity. The Taylor sisters was a notorious case where the Court of Appeal itself says, no, this is irremediable, we must take a decision, there can be no retrial. So I take your lordship's point, but either way, the purpose of doing it was to demonstrate in a practical way why the principle exists that the Privy Council itself never orders a retrial. At the most, if it considers that is a possible outcome, it remits it to the local Court of Appeal.
Well, you say that the Privy Council has never ordered a retrial, but I mean, this is a slightly different scenario in that we have a majority in the Court of Appeal ordering a retrial, and we are being asked to review that decision.
Yes.
So it's not a question of us
indeed.
coming at the question afresh.
Indeed, and one of the issues is the weight that this committee can give to the views of the majority of the Court of Appeal. In our submission, it can give none for two reasons. First, because the threshold question, should there be a retrial, requires the court to address the issue, is there a case to answer, which the President does not. And the second reason is that the other member of the majority, Judge of Appeal Isaacs, misunderstands the evidence in a very fundamental way. So he misunderstands the evidence about blood. He assumes that there is evidence.
We have a new...
Yes, no, I've been
we're all adjusting to it.
No, I've been spoken to very strictly, and I was told I was standing in the wrong place. So I've now realised I'm not only standing in the wrong place, but I've turned the microphones the wrong way. So sorry, to go back. So the only other member of the majority who gives a reasoned decision on it makes two fundamental errors about the evidence. He says that there is blood from Philip Vasyli on the appellant's clothing. There isn't. There's no evidence as to whose blood is there. All that is found is one expert says there are traces of higher primate or blood on it, and another expert says there's Philip Vasyli's DNA on it. But as the court will appreciate, and if it doesn't, I can show you the DNA primer, which was developed just for the purpose of explaining to courts how DNA works. DNA does not identify what the genetic material comes from. You need a separate statement by the DNA expert to say this is DNA from blood or this is DNA from touching. And there was no evidence of that in this case. The DNA evidence was simply there is evidence of in each case, a mixed sample, sometimes 2 people, sometimes 3 people, on each of the items of clothing, which is hardly surprising. As we all know, or I believe we all know, DNA can be left by touching as much as by contact with body fluids. So he makes a mistake about that, and he makes a mistake about the medical evidence, because having recognised the medical evidence, placed the time of death sometime on the 24th of March 2015, he then misstated how far one could count back if you took and combined that with the evidence of rigor mortis, believing that you counted back from the time the body was found, and if you go back 16 hours from when the body's found, you just about get to a time when the prosecution agree the appellant had left the house. But that was a mistake.
Yeah, I mean, this is not
yes.
my field at all, but
my lord,
what's the advantage for your client of having the decision made by the Court of Appeal rather than us? I mean,
well,
the Court of Appeal seemed to have found an awful lot of difficulty with this. We have 3 different versions of things. Surely, from your client's point of view, you want to get on with things, and we're as well
yes.
able to reach a view as anyone else.
We certainly want this committee to address the question of whether there was a case to answer. That is something that we would invite you directly to address, because our primary position is it is absolutely obvious there was no case to answer. The prosecution...
We'll come on to that,
yeah.
but we understand that.
So the second reason is because if the committee considers there may be a case to answer, the weight of that case and whether it permits the prosecution an unfair advantage by allowing them to have a second run where they get their tackle in order, where there is greater unfairness to the defendant because they've had a trial run so that they can do it better a second time round, what the evidence will be are all things that are unknown. Mr. Rowe is not...
But why are they things that the Court of Appeal will be better able to...
Because they'll have the actual prosecutor in front of them. They'll have the Director of Public Prosecutions. They will be in a position to say, for example, if the Court of Appeal says, this is a very thin case, we don't think it's likely to succeed, that is clearly not something that means there cannot be a retrial, but it is something that one, as a local court, would want to say to the prosecutor, why are you running this? You are an independent prosecutor. traditionally in most of the Commonwealth jurisdictions, prosecutions are not brought by public prosecutions unless it is more likely than not that the prosecution will succeed. That is the sort of question that would have to be directed to the director himself or his appointed representative, rather than here, Mr. Rowe, for all his qualities, can't answer that. And it will have to say, well, what are you going to do? If you're saying the blue glass man is in fact not an unknown man but Miles Pritchard, are you going to try and now put in DNA evidence from him? And how are you going to make sure that the defence are able to re-examine the material in order to confirm or deny anything that the prosecution puts forward? There are all sorts of practical problems that may emerge if that's what the prosecution wants to do.
But the questioning of the conviction in this case was based largely, if not exclusively, on the deficiencies of the trial judge's charge to the jury. Isn't that right?
According to the President, yes.
Yeah.
Obviously, there is you can mix and match a number of conclusions, and as the committee knows, there are a number of different reasons given for reaching that conclusion. But that is the starting point. The conviction's been quashed. Is it in the interests of justice for there to be a retrial? And my answer to the question, why should the Privy Council not decide there should be a retrial, is because you just don't know the facts that would be needed to be understood and examined in order to make that determination, if you consider that there is or may be a case to answer.
Would you accept that a distinction needs to be drawn between, on the one hand, a case where the quashing of a conviction is based on the deficiencies in the evidence, and, for instance, the Court of Appeal concludes that there was insufficient evidence to sustain a conviction, and on the other hand, deficiencies in the charge of a judge?
Yes, clearly. But it doesn't mean that is the only issue that will arise on the question.
I suppose your submission is, if the pretext is the wrong word, but if the occasion for the quashing of the conviction is the deficiencies in the charge of the judge, that should not lose sight of the circumstance that the prosecution, if a retrial is ordered, is given the opportunity to rejig its case.
Exactly. And there remain live issues about the fairness of the second trial, the evidence on which it will proceed, the interim publicity, all the things that would have to be considered in order to consider the overall justice of the situation. So of course, any case where where the case fails on evidential grounds is likely to be a relatively straightforward decision for the Court of Appeal. There will very rarely be a retrial in those circumstances. Yeah. But it doesn't mean that in the other cases that it's a binary choice. There will be a retrial. In the other cases, there has to be proper judicial consideration after hearing from the defence.
Good. Well, we're making good progress.
My Lord, I'm hesitate to interrupt my learned friend, but could I just, before my friend moves into the substance, just seek a little bit of clarity as to what it is in the light of that my learned friend is seeking, because she seems on the one hand to be saying that really this is all a matter of the Court of Appeal, and on the other hand to be saying your Lordship's board should decide that there is not to be a retrial on the basis of the insufficiency of the evidence. It seems to me it's unclear at the moment, and I thought I'd got it, but I have to say, listening to my learned friend open it orally, I'm not so sure I have anymore, because...
Delighted to help.
Hopefully we've got...
My primary position is that the committee should say there should be no retrial because there is no sufficient case. If the committee considers that there is a case to answer, then it should remit the matter to the Court of Appeal in the Bahamas. I'm sorry if that was unclear.
No, I think that's tolerably clear.
So I was just dealing with why it is in our submission your committee should not place weight on the decisions of the majority, and I will pick up those criticisms I make of the reasoning of Judge of Appeal Isaacs when I come to the particular matters. But the other thing that you have to note about his reasoning is it appears starkly to contradict the guidance given by the Privy Council in the decision in Reed, because he refers with apparent equanimity to the proposition that the prosecutor will indeed, as a result, be permitted an opportunity to remedy the deficiencies in their case. And he regards that as being an outcome which is nevertheless to be regarded with equanimity and permits him to order a retrial. And we would respectfully submit that Reed stands for two propositions. One, you can't order a retrial if there is no case to answer. And two, you should not order a retrial if by doing so you are permitting the prosecution to remedy deficiencies in their case as a result of having had a practice run at the process of trial. So the end point of that analysis is it is for this committee to make its own mind up on the merits without regard to the views of the majority, because neither of them grapple appropriately with the relevant legal issues, or indeed the relevant factual issues. So far as we are concerned, we respectfully submit that first of all the committee has to grapple with the state of the evidence. And as I've just indicated, that has two aspects. One is there a case to answer? And the second is, would a retrial permit the prosecution to run a different, better case to get its tackle in order, is another phrase that's used, than was the case in the first trial? In other words, would the defendant be subject to prejudice because her second trial would be less fair because the prosecutor, forearmed and forewarned, has now been able to construct answers to the points that she made in her first trial? So that's the first area, the state of the evidence. The second area is what other factors might be relevant to the interests of justice case, and should you, as Mr. Rowe urges, take a decision to order a retrial, or should you remit? So just to set out our stall on the evidential issues, this is, on any view, a circumstantial case. If the committee's had a chance at least to consider the judgments in the Court of Appeal, a number of the strands are there set out. But the reality is that in order to prove that the appellant could have murdered her husband, the prosecution had to prove the intermediate facts, as they're sometimes called, either that she was there when he died, and by there I mean in the matrimonial home rather than in the Lily Pond, which is the daughter's home some 10 minutes down the road, and secondly, that she was the only person there at that time. And that is where the evidence in relation to what we dubbed Blue Glass Man came into play. Once you've proved those intermediate facts, then it is for a jury, not all juries, but a jury, to be able, properly directed, to dismiss all hypotheses consistent with innocence. And that is simply not something that could be done in this case. It couldn't be done for at least two reasons. First, the undisputed medical evidence is that Philip Vasyli died, whatever time of day it was, on the 24th of March, 2015. And although this may not have been part of the detailed reasoning and reading that the committee was able to perform, by the time the case got to the Court of Appeal, the prosecution accepted that there was no evidence that the appellant was at the matrimonial home after 21:10 on the 23rd. That was an issue that was not conceded at trial, but was conceded in front of the Court of Appeal. So it's a very straightforward point. She leaves by 21:10 on the 23rd. It is undisputed that the time of death is the date of death, I should correct myself, is certified as being on the 24th. There is then an issue as to when...
Sorry, can I just...
Yes, certainly.
Where do we get that from?
From the death certificate, primarily, and that was stipulated as part of the evidence, but I'll give you the reference. It's in bundle 4 at 836.
Thanks.
And that's the electronic bundle reference as well, 836. So it's an exhibit. It's got out of order in the bundle, but it's an exhibit to the statement of Carla Major, which is at 829, produced at 830.
Thank you.
And it's stipulated in the trial. I can give you the transcript reference if you want it.
Sorry, what does that mean, stipulated in the trial?
It means that it's treated as evidence. So there's an admission made. It's admitted as a fact in the trial. So that you
Well, so it's common ground.
Yes.
Was it at the trial?
Yes.
I thought she said in evidence she couldn't say.
She couldn't say the time. She'd given the date. She couldn't say the time. And that's the issue about rigor mortis. So the evidence about rigor mortis also, we would submit, demonstrates that the appellant, even on its own, even without that death certificate, could not have been the assailant. And that's a point, again, that's misunderstood in the Court of Appeal. So the way one looks at the rigor mortis evidence is as follows. Prosecution called the evidence. This wasn't part of the defence cross-examination. It's introduced in chief that there are signs of rigor still present in the body when it's photographed at 13:15 on the 24th of March. And in fact, the sign of rigor is clearly a rigor that's been tested because it shows up. The body is lying on its face with the arms under the main chest area, and it is then turned over. This is in the supplementary material that I'm hoping the committee doesn't have to look at, but we provided it. It's then turned over to be put into a body bag, and it's apparent that once it's turned over, that one of the arms is still in the air, and it's that arm still in the air that the doctor comments on as showing that rigor is present and has not broken. So in other words, it is still either at or coming to the peak of rigor, so the body is some 4 or 12 hours from death.
After the peak of rigor, it doesn't just disappear.
No, but if you then push it, once the peak's gone, if you push it, that's the whole point about it, him having his body weight having been on it. If you then lever it as you do, just flip the body over, in other words, you break or try and break the rigor, if you've gone past 12 hours, it will then become flaccid. It'll break.
Is there evidence about this?
Yes, the doctor's evidence about it. So the doctor's evidence was that you get, the peak is at 12 hours, it will then break and become flaccid up to 16 hours. And that's where the judgment of the Judge of Appeal, Isaacs, goes wrong, because he recognises that's the framework, that they've got to be able to count back 16 hours in order to say that, given the state of rigor, the appellant is a possible assailant. And if you count back 16 hours from 13:15, you come to 9:15, 21:15, when she's already left, when the prosecution accepts she's not at home, she's at the Lily Pond house. So having stated that, as he does, he then goes on to say, but that's a point for the prosecution, that it's 16 hours from the time the body was found to when she left, which would be a feasible period. If one was counting 16 hours from 7 o'clock in the morning when he was found, then it does mean she's a possible assailant. But that's simply a misunderstanding. He'd forgotten that the evidence of the rigor and its existence and presence had to be counted from 13:15, not from 7 o'clock in the morning when the body was found. So I'm sorry I got diverted, but my first point is that undisputed medical evidence called by the Crown, adduced by them as part of their case, demonstrates that Philip Vasyli died at some point, nobody can be certain of the time, on the 24th of March, at a time when the appellant cannot be his assailant. The second evidential issue that in our submission is unanswered by the prosecution is the fact that it is clear from the scene and accepted by the police officer who was the scenes of crime officer that there had been 3 people sitting outside the matrimonial home at some stage on the night of the 23rd, 24th of March. And the DNA evidence demonstrates that the 3 possibilities are...
You say on the night?
Because, firstly, that was the scenes of crime officer's analysis of the scene that presented itself. Secondly, because it is clear that there had been a much bigger party at the house earlier in the day. So there was a man called Miles Pritchard and his wife Jodie, and there's a man called Mitchell Matthew. So 5 people in total. And it was clear from the scene that the detritus from that visit had been cleared away. And Pritchard and Mitchell Matthew had both been drinking beer, and in the bin in the kitchen were the bottles of beer that the prosecution said at trial was the beer that they'd been drinking. So the scene that presents itself is of the table where there had previously been 5 people, with the bottle of wine and the bottles of beer tidied away from the 5, and 3 glasses remaining, appearing to be in active use. They're sitting on the table. And again, I've got part of the extra bundle which Mr. Rowe complains about shows you that scene. But it as I say, it's not just my assertion on the photo. It's accepted by the scenes of crime officer that his analysis of that scene was that there had been 3 people present. And as I think the committee appreciates, those 3 people are the appellant, Philip Vasyli, and an unknown male who we've called Blue Glass Man.
How do we know it's a male?
Because the DNA Y profile shows it's a male.
And they were drinking wine, were they?
The glasses were not all full. One is half full and appears to be wine. The other one is empty, as is the blue glass from the photos. But there wasn't any evidence about that. But from the photos, they appear to be empty. But the important point that it's now suggested that the answer to the possibility that there is a 3rd person present at some stage that night is that it must be either an earlier visitor or Miles Pritchard. There's simply no evidence of that. And as the Court of Appeal observed, it is for the prosecution to prove, if that's their case, that proposition to the criminal standard. They cannot rely on speculation. But more importantly, that wasn't their case at trial. Their case at trial really consisted of doing 2 things. The first was to say, well, effectively, it can't have been an intruder, and therefore, whoever else is at the table, it has to be Mrs. Vasyli, despite the fact that didn't make sense. And secondly, when the defence make a speech saying there is this unknown male who's been drinking from the blue glass, they suggest that it may be the DNA of the grandson, which it isn't. That's simply a misunderstanding. There are indeed two unknown men, one whose DNA is on the blue glass and one whose DNA is on the multicoloured dress. It's the grandson whose DNA is on the multicoloured dress, not on the blue glass. There are two unknown men, one of whom clearly is most likely the grandson, and that's on Donna Vasyli's dress, hardly surprisingly. And coupled with that evidence of the presence of the blue glass man is the fact that it is clear that Philip Vasyli, having been injured outside, that's clear again from the scene because there's a mass of blood spatter outside, consistent with both his being stabbed there and also what looks like cast off on the canvas above the dining table. Philip Vasyli has gone in and quite clearly locked the internal door against whoever his assailant was. Because you can see, and again, these are the photos that Mr. Rowe objects to, you can see his bloodstains on the internal locking mechanism. And the reality is that he would not do that or think that was possible if his wife was the assailant, because there was a door just next down to what's called Lauren's room, which didn't lock. So that if you lived there, if you were the appellant, having the kitchen door locked meant nothing because you could simply go in through Lauren's door. It is, however, consistent with this being the blue glass man being a visitor whom Philip Vasyli was trying to get away from, hence going into the kitchen and locking the door. I ought to say something briefly about the evidence of blood and DNA, because that is something that's relied upon both by the trial court and by the Court of Appeal, the majority of the Court of Appeal. Firstly, there is no evidence that Philip Vasyli's blood was on any of the clothing. As I've already indicated, there are two separate strands of evidence. One is that there are traces of blood invisible to the human eye, which is either human or higher primate blood, on two items of clothing. Separately, there is evidence of 2 or 3 mixed profiles of DNA on the clothing. Actually, in some cases, 4 mixed profiles. But in any event, there is DNA evidence of mixed profiles on the clothing, which includes profiles from Philip Vasyli, the appellant, her grandchild, and other unknown people. And persistently, that has led the court to say there's evidence of Philip Vasyli's blood on the clothing. There is not. That is simply a misstatement. It's a misstatement begun by the prosecutor, adopted by the Court of Trial, and followed by the majority of the Court of Appeal. The second point is that even if there was evidence of Philip Vasyli's blood, nobody is able to date or time the circumstances in which it might have come to be on clothing, because it is again undisputed that Philip Vasyli had fallen down the stairs, had cut his back, and had been wandering around the house bleeding from an accident earlier in the day. That is undisputed. Again, I've got photos of the wound which show that his back had been bleeding, and there are photos of the upstairs of the house where nobody suggests he went after he'd been attacked, with blood scattered through the bedrooms and bathrooms. So even if there had been evidence of Philip Vasyli's blood being on clothing, that took the case nowhere, effectively, because it was impossible to determine when these traces of blood might have come to be on the clothing. But perhaps more importantly, if there is anything to be made of the state of the clothing, it is that there is no sign of any dynamic blood staining. And by dynamic blood staining, I mean, for those of you who haven't tried a lot of criminal cases, the sort of blood staining that you get as a consequence of being in the vicinity of somebody who has, in this case, an artery severed, when, as the scene photos showed, you get, and as the judge put it, you get blood that goes up, out, and everywhere. And that gives you then wet blood on clothing, and it gives you wet blood, which has clearly been the subject of fluid dynamics by being rushed through the air, and it is easily identifiable as being signs of being in proximity of the sort of stabbing that we have here. Nothing in this case. It appears, in fact, that the blood was not even visible. It was simply produced by swabbing with some form of solvent the clothing in order to produce the trace that was found.
But of course there's no immutable pattern to all of these.
No, indeed. But the point I'm making is, firstly, there isn't any evidence of any of his blood on her clothing. Even if there were, it gets
These are all extremely good jury points. But are there points which go to the question of whether there is a prima facie case?
They're not only extremely good jury points, my lord, they are the points that were made by the judge in answer to the submission no case. But his blood's on her clothes. And if there is no evidence of that fact, and my submission is there is plainly...
Yeah, we're going back to your first submission then.
Yes.
Yes, go ahead.
Yeah, no, I'm not trying to make a jury speech to your lordships.
No, of course not. Of course not. But,
I am genuinely trying to grapple with the things that were said to be the basis for concluding that there was a case to answer. Oh, well, the time of death, it could encompass her if one makes a mistake about the rigor calculation. Oh, the presence of blood has to be explained. No, it doesn't, because there isn't any blood that's present. So what I'm addressing here is not...
Yes, but you're going further, simply saying that there isn't any blood that is associated with him on her clothing. And you're now dealing with the later point.
Yes.
Even if that could be accepted, that there's a sufficient explanation for the presence of blood, or at least there's one that is inconsistent with guilt.
Yes. And as your lordship knows, it's the hypotheses inconsistent with guilt that a jury has to be able to dismiss.
Yes. But the task for a judge at the stage of deciding whether to give a direction is whether it is safe to leave the case to the jury. In other words, whatever personal view she or he might form about the cogency of the evidence, it's ultimately for the jury to make a judgment about this.
Absolutely, but it does involve the judge saying, could a jury, not all juries, but could a jury, properly directed, safely reject, to the criminal standard, the hypotheses consistent with innocence?
Right.
Can I just ask you, going back to your former point about whether there was identified blood on the clothing, where the statement is dealing with lifting of the sample for testing?
It's an unsatisfactory position. So the evidence in relation to the finding of the blood is in relation to the scientific officer Blair, who deals with this at volume 4. At 4893, I think it is. Let's check. Yeah, 893. So So this is it's sometimes called the multicoloured dress. It's also called the floral dress. It's MC16B. Does your ladyship have that?
Yeah.
No sign of damage, soiled and stained. Higher primate blood was identified on the front right sleeve cap. And then over the page, the blue dress, 894 EM2, the second item down,
Yeah.
soiled and stained, higher primate blood near the crotch.
Yeah. And then where's the DNA?
DNA is in a number of places.
I want to know in terms of the position of the sample that was tested for DNA.
Okay, so the DNA on the multicoloured dress first is done on the two cut-out stains. So for reasons that are not clear, the right shoulder and the left sleeve were cut out, although that's not detailed there. And I can take you to the evidence of where it's dealt with. And those two cutouts were then analysed the first time round on the DNA. So I'll give you the DNA.
So where I'm getting to is,
yes.
is it the same position on each of those pieces of clothing that was said to be blood and tested for DNA?
No. It's basically there are two cutouts taken. So I'll give you the references. So in terms of the floral dress, the first DNA statement is at 9:08. These are the two cuttings from the dress. Not the swabs, which were obviously tested for blood.
So which one are we on?
So 908 MC16B stain 1.
Thank you. Oh, stain 1.
And MC16B stain 2.
Okay.
And as you see, mixed profile on 1, profile for Philip Vasyli on 2, and a mixed profile on the blue dress, which is immediately below it.
It was the position of the cutting that...
Yes, no, well, unfortunately there was no direct evidence for that. The only evidence on it was given by a live witness, Sharia King, who gave evidence at trial dealing with this at volume 3, 531. And she, basically the evidence from her was led by the Crown.
Sorry, who is she?
My Lord, she's in volume 3 at 531.
She is?
She is the senior forensic officer who also was responsible for overseeing the transmission of the samples. She didn't do any of the sampling. And indeed, there was an objection to her evidence on that basis. So just to introduce her, you can see, if Lady Back's interested in the testing, at 527, she's describing as a matter of principle what should happen, that you'd swab and then add a solution to the area and then do your testing on that, although this is entirely her hypothesis because she doesn't take part in it. And I should emphasise nobody suggests there was a visible blood stain on it, that there's no evidence of that. And then she deals with the cuttings at page 531, and she explains, top of that page, line 5, that what was cut was the left sleeve and the right shoulder.
So the right shoulder is where the DNA, where the
blood, if that's what the
where
right,
the blood and the DNA.
If that's what the right sleeve cap means, yes.
Yeah.
It's the multicoloured dress.
That is the multicoloured dress.
The other one is the blue dress. Is it a dress or a night dress?
It's a dress. Oh, it's a night dress, in fact, when you look at it. I would describe it as a night dress. It's a cottony, soft thing, knee length.
So your point about the shoulder cap one depends on it not being sufficient to establish that it was his blood as opposed to his DNA,
Yep.
that it was taken from the
Yep.
same place?
Potentially, although there's no evidence as to the
millimeters.
precise, indeed. So one only has to think about it. If you're going to have touch DNA as opposed to blood DNA, depending on the size of the cutting, and it appears to have been a very large sized cutting, you're going to run the risk that if you haven't excised, if it's a single point of blood on a square millimetre of cloth, then your ladyship would be entitled to say, well, one can infer in those circumstances if the DNA turns up.
I've got the hang of the point,
Yes,
I think.
yes.
Thank you.
The problem is there was simply no evidence, and there was certainly no evidence of anything visible which would allow you to say, right, they've definitely cut out the bit that had the blood in it, and therefore we can be sure the bit that had the blood in it is what's gone to the DNA expert.
Right.
I'm sorry for the detail, my Lord.
No, there's no need for apology, but let's move on.
Yes, certainly. So I've dealt with the absence of evidence of the blood, and in those circumstances, the only point of any weight that remains of the prosecution case, that at least so far as the Court of Appeal and the judge at trial were concerned was relevant at the no case analysis point, was the statement by the policeman who says that she described having a fight with her husband when he first spoke to her. But the difficulty with that, and indeed it's a difficulty acknowledged, because neither the Court of Appeal nor the trial judge pinned their decision on it, was that it was clearly equivocal. There had clearly been an argument earlier in the day about his drinking when he fell down the stairs, and even the prosecution accepted that the nature of the fight, whether it had been verbal or physical, was a relevant issue, and they could not say which it meant, and indeed it wasn't explored with her when the statement of the policeman was put to her. So I ought to just briefly take your lordships and my lady to the case of Reed, so that you can see at least the principles that are in play according to that decision of the Privy Council. That's in the authorities bundle behind flag 10. If you're following it electronically, it starts at 1805. And this is a pair of cases, in fact, as is often the way in the Privy Council. It's paired with the decision behind flag 4, 1732, the decision in I. Poi Kuhn from the Hong Kong Court of Appeal, which was argued and decided on the same day, so they can be read together effectively. But I think I can get most of what I need from Reed, other than to observe that in Ao Poi Kuhn, what I suggested should have happened did happen. The Court of Appeal reopened a decision on retrial and allowed it to be reheard in Hong Kong rather than sending it up to the Privy Council, and that's what should have happened here. But turning to Reed, so behind flag 10, the case depended on a single eyewitness and ordered a new trial in circumstances where they accepted there was not on the case presented a case to answer. So in that sense, I do accept that that is the factual premise for the reasoning of the court. But as you'll see at page 1808, 346 in the report, between D and E, having considered the terms of the Jamaican appeal provision, which is identical terms, perhaps not surprisingly, to the Bahamian one, court shall, if it's in the interest of justice, order a new trial. Any consideration may call for a balancing of a whole variety of factors, some of which weigh in favour and some against. The weight to be given to those factors may differ from case to case and depends very much on local conditions with which the Court of Appeal is much more familiar than their lordships and better qualified to assess, which is why, as I said to my Lord Kerr, the question is not simply a binary one, is there a case to answer, retrial? And the point is made that the Privy Council will only interfere with the decision of the Court of Appeal to order a new trial unless the Lordships are satisfied that the Court of Appeals erred in principle by taking into consideration some matter which they should not have paid regard to, or failed to take into consideration some matter which they should have paid regard to. And that's why I was at pains to say that we do challenge the basis of the reasoning of the Court of Appeal in our case. Then, so far as the interests of justice are concerned, at page 1810 electronically, 348 in the report, between A and B, the Privy Council make the point that it is in the interests of the people of Jamaica that persons guilty of serious crimes are brought to justice and should not escape because of some technical blunder in the conduct of the trial. But there are, of course, countervailing interests of justice which must also be taken into consideration. The nature and strength of these will vary. One of them is the observance of the basic principle that it is for the prosecution to prove the case against the defendant, and it is their function to decide what evidence to call. And so, as picking it up at E on that page, it would conflict with that basic principle if a new trial were ordered in cases where at the original trial the evidence which the prosecution chose to adduce was insufficient to justify a conviction. And as they say at F, to order a new trial would be to give the prosecution a second chance to make good the evidential deficiencies in its case, and if a second chance, why not the third? And for that reason, they conclude that in Reed, this is at H, the case falls into the category in which a new trial ought not to have been ordered.
Because there was no case.
Because there was no case, and because it was necessary. But in my submission, you're seeing here two linked reasons. One, no case, and two, that it would not be right to permit deficiencies in the first trial to be put right in the second. Now,
Deficiencies that meant there were no case. So it's obviously different if there was a sufficient case.
Yes, but it would still be relevant. If we look at this and we can see they deal with what is the strength of the case, and is it, if it's merely an improbable but nevertheless a sustainable one, what should the approach of the court be? And they deal with that at page 350, Electronic Bundle 1812. And there you see they are dealing at between B and C with, assuming there is a case to answer, there will be other factors deserving of consideration: seriousness of the offence, prevalence, expense, ordeal to the defendant, length of time. And then at E, they turn to the strength of the case. The strength of the case presented is always one of the factors to be taken into consideration. But except in the two extreme cases, that is, where it's inevitable and where it's not proved, the weight to be attached to the factor will vary widely from case to case according to the nature of the crime. And they make it clear that the fact that a conviction is improbable, it does not necessarily lead to a decision there should be no trial, but it may. That's between F and G. It's not necessarily a condition precedent that the Court of Appeal should be satisfied of the probability. That may require some adjustment in modern times, I have to respectfully submit, because the modern approach to prosecution through the Commonwealth is that there should always be, at least when the prosecution is brought by a public prosecutor, an analysis that allows you to conclude a conviction is more likely than not. I have to say that the state of the law in the Bahamas is possibly less clear than it might be, because they've only had an independent prosecutor, that is independent of the Attorney General, for 2 years. Before that, under their constitutional arrangements, the director was subordinate to the Attorney General. But since, I think, 2018, they now have an independent prosecutor, and presumably he will issue his own, or he or she, it's a he at the moment, will issue their own guidance as to when it's appropriate for public prosecutions to take place. But the norm now, it wasn't the case in 1980, is for public prosecutors, and there's a public prosecutor pledge both in Europe and through the Commonwealth that says public prosecutions will only be brought where a conviction is more probable than not.
Yeah.
But in any event, if it is a very weak case, that is something where I would submit the court, and this committee should say to the Court of Appeal, you should be considering whether you're going to allow the prosecutor to transform what is an improbable case into a probable one by rejigging their case, by producing fresh evidence which should have been and could have been available first time round.
But, I mean, is that a factor here? I mean, no one's suggesting there's any other evidence.
I just don't know, my lord. If the conviction has been quashed and a retrial ordered, it is not clear to me what case the prosecution would be presenting and what evidence it might be putting forward.
Sorry, I mean, is there any reason to think they'll be producing any different case than they did before?
I imagine there is. Mr. Rowe has said that this committee can be sure that the blue glass man is Miles Pritchard. I would hope that...
Obviously, there can be some DNA evidence on that factor, which may well tend to your favour.
It may well, but that's an example of an area where I just don't know. Are they going to test Miles Pritchard? I believe him to be at least a resident or a part-time resident of the Bahamas. They could have done it.
Might there be evidence as to the bloodstains in the sauce?
Indeed. I don't know whether they've been destroyed or not. That's the other thing. So that the process of testing does sometimes mean that you're not able to then re-perform tests. And so again, I suspect there won't be any further evidence of visible blood because it was common ground that whatever blood was present, it was invisible to the human eye.
I was thinking of the source of the
Yes, indeed. Yeah. Yes. Although, frankly, given that it's a mixed DNA result, it's probably unlikely that it's sufficiently good to be able to say what the source is, touch as opposed to...
Yeah, but a distinction has to be drawn, does it not, between the situation where it's clear that the prosecution not only has the opportunity but will avail of the chance to mend its hand, so to speak.
Yes.
And on the other hand, the situation in which we now seem to be discussing where it's speculation as to whether or not it will mend its hand.
As the committee appreciates, I'm dealing with two issues. One, is there a case to answer? Yeah. Two, if there is, should you decide that there should be a retrial? That's Mr. Rowe's contention, and I'm saying he's wrong in that.
Yeah.
The committee just doesn't have the information that it needs in order to make that decision.
Yeah. Well, how would the Court of Appeal be put in a better position than are we to decide? I mean, surely it would be a matter of speculation for the Court of Appeal as well. Well,
the Court of Appeal sits locally, my lord. It sits in Nassau. The director, because in fact Mr. Garvin, the prosecutor in this case, is now the director, will appear in front of it. It will be entitled to say, as any Court of Appeal would, what is your case going to be on the retrial? If you are going to say it's Miles Pritchard, what are you going to do about that? Because at the moment there's no evidence of that.
Yeah. Right, let's move on.
So, I ought to turn then to just deal with the reasoning in the Court of Appeal, since we are critical of it and we invite your lordships to say that it should not be followed. So that's volume 1 of the record. And the reasoning of the President starts at page 99 in the electronic bundle. And she deals with the question of both retrial and prima facie case at page 113. So it's 113, paragraph 49, for the reasons indicated by Judge of Appeal Isaacs, I would remit the matter to the Court of Appeal. Paragraph 50, as the matter is being remitted, I make no further pronouncements on grounds 2 and 4, which raised whether there was a prima facie case, which call for an examination of the evidence. So she does not consider whether there is a case to answer. She simply adopts the reasoning of Mr. Justice Isaacs. So far as Mr. Justice Isaacs is concerned, he deals with this, the question of the sufficiency of the evidence in two places. Firstly, he begins his analysis under the heading on page 127, electronic bundle 127. This is dealing with the blood evidence as he puts it in the heading. And at 128, paragraph 89, he deals with the absence of evidence as to transmission onto the clothing, which indeed there was no evidence. But he concludes, nevertheless, the presence of the deceased's blood on the appellant's clothing is a matter for the jury to consider. And I think the committee now knows I say that is wrong. There was no evidence on that. So far as the DNA is concerned, as you will see at paragraph 94, he acknowledges that the presence of an unknown male's DNA, blue glass man, does raise a question about the soundness of the prosecution's case. And the reference to the cat and mouse is because the prosecutor opened the case on the basis that there was one cat and one mouse, and therefore when the mouse disappeared, you could be certain the cat had eaten it. But as he pointed out, that had to be considered by the judge. There was no direction to them by the judge in his summing up as to what the relevance of the unknown man's DNA was. And if he concluded the circumstance did not fatally weaken the Crown's case, then his direction should have disclosed it. The reason for the conditional is that the judge just doesn't deal with it at all. It's been raised at the close of the prosecution case. The defence have pointed out that the cat and mouse analogy is inapt because there are on interview two cats, and he just ignores it when he comes to give his decision as to whether there's a case to answer. Video discs I can ignore, bloody footsteps I can also ignore. They aren't the appellant's. They're clearly those of Philip Vasyli. And then rigor mortis timeline begins at 104 and runs through to 108. Uh, 105 is a correct summary, as we would submit it, of the undisputed evidence of Dr. Sands on rigor. It's the last four lines. She describes how the condition sets in 2 to 4 hours after death. It peaks at about 12 hours and it softens after that. Her opinion is unchallenged. This would mean, therefore, that more likely than not, the deceased met his death around 14 to 16 hours before 1:15 p.m., which, as I pointed out, means it is not the appellant who killed him, because by then she is at the lily pond. The problem is...
Well, 14 to 16 hours would take you back to 9:15.
Yes, she is at the lily pond by 9 or 9:10.
Yes, that's very clear.
It's a 20 minutes walk.
But all these timings were said to be depend on various factors.
Indeed. But I can go back to the death certificate. Unchallenged, introduced by the prosecution as part of their case. Because at that stage they weren't accepting the lily pond evidence. It was really only when we came to the Court of Appeal, when he was questioned about it by the judges in the Court of Appeal, he was forced to accept that the evidence of Mitchell Matthew had been read to the jury and admitted as evidence of the truth of its contents, as the judge directed the jury, and that put her at the Lily Pond by 9:10 at the latest.
Do we have to take the death certificate as an incontrovertible statement that the death occurred on the 24th?
Well,
What should it have said if it was uncertain?
it should have said uncertain or 23rd/24th. I mean, in the end, this is the evidence presented by the prosecution. If it is correct, that is a hypothesis that is only consistent with her innocence. What was the material that would then allow a jury, properly directed, to completely reject that and say, no, the death must have been on the 23rd?
But there's a danger, is there not, in treating evidence which can be analysed as showing a particular result as establishing a proposition which is incontrovertible. The whole nature of a criminal trial is that it's organic.
My Lord.
There's reaction to the unfolding evidence, and it's only where there is no possibility of the well, not only where there's no possibility, only where it would be dangerous to allow the jury to conduct its traditional role of assessing the evidence and reaching a conclusion that it would be appropriate to withdraw it from their consideration. The judge has to be zealous not to supplant the role of the jury.
My Lord, I accept that, and I hope my submissions are doing no damage to that principle. This is not evidence in the realm of controversy. It's not defence evidence that I'm relying upon, where there's a challenge by the prosecution. This is material produced on examination in chief by the prosecution about rigour.
But I mean, your point is that 108 is simply wrong.
Yes, it's simply wrong.
I mean, you seem to be sort of getting diverted from your key point. I mean, what you're saying, as I understand, is that paragraph 105, he says correctly.
Yes.
I was looking for 16 hours.
Yes.
115.
You don't count back from when the body's discovered.
Yes, clear inference that she couldn't have done it.
Yes.
But then he says, well, 16 hours before the body was discovered.
Exactly, which is 7 o'clock in the morning.
Point, and he then
Yes.
says that's a matter for the jury.
Yes.
So one wonders really what the jury and earth were meant to make of all that.
Well,
But I mean, if what he says in 105 is right, then you say there isn't a case.
yes. The point is that we're not in an area with the death certificate where there's room for another narrative which says death's been certified on the 23rd.
Well, can I just ask you
it
about
seems
that?
to me, with respect, that when the certificate was filled in, it wasn't presumably being worried about precisely what the time of death was. It just had to be got a certificate. Whereas this point seems to be a much stronger point, isn't it?
Well, they go together. It's filled in, my lord, at the post-mortem, by which point I think she's been charged. So it is a...
Can we just try and track down? It's the pathologist is Dr. Sands.
Yes.
There must have been a report from Dr. Sands. Was it read at the trial?
As I understand, I've never seen the report from Dr. Sands. It certainly wasn't read at the trial.
Because sometimes what happens in this is people say, let it be treated as read in,
yes.
and we can never find what's been
Yes.
read in.
I can show you where the...
So where's Dr. Sands' evidence about
Dr. Sands' evidence is in volume 3.
Yeah.
And it does...
Where's her evidence about her conclusions reached at the post-mortem?
There is evidence only about the mechanism of death and rigour. There isn't evidence that deals with the certificate. So her evidence starts at page 578. And it runs through to 597. So the certificate comes in through the statement of the police officer, not through Dr. Sands.
Yeah.
And you can see she refreshes her memory from a report which does not go into evidence, dated the 31st of March. That is the death certificate, I believe, because that's the date on the certificate. And she deals with the mechanism of death. As you can see, died from a stab wound. And then she deals with rigour as a result of the question by the prosecutor, bottom of 580, reading on to 581, and that's where the evidence comes, bottom of 581, 2 to 4 hours, peaks at 12. That's an average, to take my Lord Hamden's point.
So she's never asked, what do you put on the death?
No. Oh, she's asked about time, not about date. She's asked about timing by the defence at 588 in the middle of the page. So she's given the evidence about rigour. Are you able to determine the time of death? I don't know the time of death. So just when you've...
Was the certificate point relied upon at trial?
No.
The Court of Appeal?
Yes.
The evidence that she gives in relation to rigor mortis and when it sets in and when it peaks isn't absolutely clear that it's 16 as the total of 12 plus 4, is it? It takes approximately 2 to 4 hours to be noticeable for you to appreciate it, and then it peaks at about 12 hours. When I was looking at this yesterday, I was wondering whether...
No, it's clearly understood by everyone as being...
16.
12 to peak, from death to 12 peak. So death to 4, no rigour. 4 to 12 peak. 12 to 16, wearing off.
Right.
And yeah, that's certainly the basis on which it's summed up and which the prosecution presented it. So as I said to my Lord Carnworth, 105 in Judge of Appeals Isaacs is correct. It means that if rigour's present at 13:15, you're counting 12 to 16 hours back, max.
Thank you. So far as the decision of Judge of Appeal Isaacs is concerned, having dealt with rigour, he then turned to deal as a separate topic with the question of whether or not there should be whether or not the judge was right to decide that there was a case to answer, and he deals with it in two ways. He looks at the statement made by the appellant. He recognises the judge's decision at 113 does not grapple with whether what she was describing as a fight had been verbal or physical. And he says, in a sentence I have to say I've struggled with, at paragraph 114, having considered the various aspects of the Crown's evidence, that's the admission, the rigour, and it cannot be said that the jury would not inevitably have concluded the appellant was responsible. I can't improve on it. I had several attempts.
Yes. And then he looks again at the issue through the prism of the decision made by the judge to allow the case to go to the jury. And he analyses that at paragraph 121, recognising that there are competing hypotheses and accepting correctly in our submission, citing Varlach at 119, a decision of the Judicial Committee, that it's only if a jury can reject hypotheses consistent with innocence that there's a case to answer. And he says at 121, there were competing hypotheses in these cases, Blue Glass Man and the time for rigour, but on the Crown's reliance on the admission of a fight, blood on the appellant's clothing wrong, and no evidence of forced entry. I'm not sure
where that's going. The whole point about Blue Glass Man was that he would have been a visitor. The issue is, if accepted, was it capable of causing a reasonable man to exclude competing hypotheses? And he says the judge's statement discloses nothing more that the jury may ultimately find the Crown's case less than compelling. Once again, that doesn't grapple with the central question is, how would a reasonable jury, properly directed, reject the competing hypotheses he's identified? Namely, that the time of death means she wasn't present, and Blue Glass Man means she wasn't the only contender. What is more worrying, so far as he is concerned, is it's quite clear that he contemplates that the retrial will involve, or may involve, a breach of the Reed principles. So he sets out his reasoning on the retrial beginning at page 135. Paragraph 135, electronic bond 139. And he quotes extensively from the Diplock decision. And then at 137, he seems to regard with equanimity what Lord Diplock says shouldn't happen, because he says this: on a retrial, the Crown may very well take the opportunity to make good such deficiencies in its case that can be cured. Nevertheless, the interest of the public, that persons guilty of serious crime should be brought to justice and not escape because of technical blunder, leads me to conclude that an order for trial would be in the interests of justice. That is a wrong approach. At the very least, if, as he seems to accept, there is a likelihood of the prosecution effectively curing deficiencies in its case, having a second go at bringing a better trial because they've realised its flaws in the course of the first, that would be a matter that would weigh very heavily against ordering a retrial, particularly if what he's doing is recognising this is an exceptionally weak case, even if he's saying there's a case to answer. That would be of very great weight in the decision-making process. But fundamentally...
If a Court of Appeal decides that a conviction is unsafe and must be quashed because of deficiencies in the charge by the judge to the jury, but at the same time recognises that there may be, if a retrial is ordered, the opportunity for the prosecution to cure perceived defects in the presentation of the case, notwithstanding that those deficiencies were not the warrant for the quashing of the conviction. Is the Court of Appeal precluded from ordering the retrial, notwithstanding that it recognises that this may give the prosecution the opportunity to overcome incidental difficulties in their case?
Precluded, no, but relevantly required to consider what the impact of that might be on the justice of the case, absolutely. Because one of the issues is always going to be, for the reasons stated in Reed, what is the strength of the case? What is the justice of allowing a prosecutor who's chosen deliberately to run a thin case first time round, running a thicker and more substantial one second time round?
That begs the question, doesn't it? That the prosecution has chosen to... I mean, I can quite understand where the prosecution has chosen to present a B division case. It shouldn't be because of some incidental basis for quashing of the conviction, be given the opportunity to present its A case. But when you say, in answer to my earlier question, that the Court of Appeal isn't precluded from deciding to order a retrial, but it's got to consider the impact of the opportunity afforded the prosecution, and how does one set about considering the impact afforded the prosecution?
Well, it's considered at a practical and evidential level, my lord. So if we take this case as an example, if we are going to say, well, let's retest the blue glass for Miles Pritchard DNA. Is that possible? Is the glass still available? Has it been kept pristine over the 5 years that have now elapsed? Is that something that's going to be feasible? Will the defence be able to test it? So you would look at it in a practical way and say, okay, if you want to improve your case by testing Miles Pritchard, what is the impact going to be upon the fairness of any trial that might result?
Yeah, and your point is that that's best done by the Court of Appeal.
It can only be done by the Court of Appeal. This committee is not in a position to do that.
Right.
And it's why I made, I hope mildly, my complaint in the face of Mr. Rowe's plea for expedition. I raised the point as to why it was that we'd been forced to come to this committee rather than have the matter, by their consent, recognising the injustice done to us, remitted to the Court of Appeal when it was seized of the matter, when it had all the videos and when it had all this evidence.
Right.
So now we are,
I think we have that point.
So, I've dealt with the criticisms we make about the approach of Mr. Justice Isaacs. So far as the procedure that should be adopted, if the committee is going to send this back, it is clear in my submission that in a case of this complexity, there should always be an oral hearing. That's not something that necessarily the Privy Councillors grapple with, but certainly the Court of Final Appeal in Hong Kong faced with the same problem where retrials were being ordered without hearing from the defence. The Court of Final Appeal in that case, with Lord Wolfe, I believe, delivering the judgment of the Court of Final Appeal, expressed the view that in a complex case, the issue of retrial, if it goes back, has to go back for a proper hearing with further argument. And I'm not sure your lordships need to look at it, but if you wanted the reference, it's in the decision in James Henry Ting, which is behind flag 11. And the relevant passage from the judgment is at 1836, paragraph 56. In a complex case where retrial is debatable, there must be a separate hearing on the question after the outcome of the appeal is known. So it's, my lord, it's flag 11, and it's right at the end of that judgment, 1836.
Yes.
At paragraph 56. I should observe, just for completeness, that is obiter, because in fact Lord Wolfe ordered there should not be a retrial in that case. So I think in terms of authority, those are the only matters I need to draw to your attention, save that I ought to make it clear that so far as the defence are concerned, it is a matter of regular practice that the matter should be remitted, and that we can get from the decision in Bennett behind flag 5 in the authorities bundle. The practice is dealt with in summary at page, it's at electronic bundle 1741, and the passage I just want the committee to look at is at 1757. So Bennett, flag 5, 1741 at 1757. And it's in paragraph 41, the conclusion. I'm not going to go through the cases that lead to it. In remitting to the Court of Appeal the decision whether there should be a retrial, the issue is remitted for decision in accordance with the well-established practice of the board. It is not feasible for the board, and it is not its function, where the facts are not clear and require further investigation, to grapple with the issue whether there should be a retrial. And before we leave Bennett, it is worth just glancing at the analysis of Lord Steyne dissenting mainly for the principle rather than for the decision on the facts, because if you just turn to the next page, 1758, he observes that at paragraph 44, a suggestion that it was normal to have a retrial, that a case demands an intense focus on the particular circumstances surrounding each case, and at 45, that an order for retrial is not a mandatory order, but in truth leave granted in the exercise of the discretion of the court to present the charge. The prosecution is in the driving seat. If it considers it's not practicable, it may abandon it. And he makes the point that one of the things the court will have to consider, this is at paragraph 48, page electronic bottle 1759, para 48, amongst the factors to be considered, according to him, and in my submission correctly, is it always important to consider whether in the particular circumstances a retrial can take place without unfairness to the accused. An order for a retrial may only be made if the interests of justice so require. And he gives examples of that as being, and this is why I separated out, my lord, as a separate factor, instances of unfairness are where an important witness has died, that's in the middle of the paragraph, and where the prosecution are not being given another chance to cure evidential deficiencies, Reed and Nichols. And in our respectful submission, that must be right, with an open-textured discretion as to the interests of justice. Potential unfairness of that sort is bound to be a relevant consideration in every case.
Yes.
So I was going to deal briefly with some of the page references to the evidence, some of which have been picked up by questions raised by the Judicial Committee. But so far as the death certificate is concerned, I've already given you the references that it is the decision of, it's produced by Carla Major, and I think at least Lady Black looks at it, where it appears in volume 4 at page 836. And that's where the date 31st of March comes from, which is the date referred to in the transcript of the evidence of Dr. Sands. So she's referring to her report when she does as one dated the 31st of March 15, and that's what she certifies in box 7 on the form. And it's introduced into evidence recorded in the transcript at volume 2 at page 517. And just to answer Lord Carnworth's question, this is how it's done. Mr. Brathwaite at 517, line 7, says, this is the report of Woman Detective Corporal Major. We ask this be admitted and marked DV 29. And DV 29 at line 19 is marked and received, and at line 21, report read into the record. So, and she's the woman who produces the certificate. And so the way in which it works in the Bahamas as a matter of evidence is very similar to the laws here in the United Kingdom. Evidence is either called or by agreement between the parties may be read. In fact, certainly in the United Kingdom, and I suspect the same rule may be true, where evidence is read by agreement, the jury are directed, they must accept those facts because they are agreed between the parties. So just to deal with my Lord Kerr's point, that we are not here dealing with evidence in relation to which there's an ebb and flow and which the jury are free to pick and choose what they accept and what they don't. We're dealing with evidence admitted by agreement between the parties and therefore evidence that the jury are bound to act on. So that's the evidence on the death certificate. So far as the evidence on rigour is concerned, again, I think the court has seen enough of the evidence of Dr. Sands. Perhaps the only bit I didn't show you is where she confirms that, in her view, rigour is present in the relevant photo, which is after the body has been turned over, in other words, that the rigour would have broken. And that is in volume 3 in her evidence at 587. And it's in the middle of page 587. She's being asked to look at, well, just above that, she's looking at a photograph and she's asked about the position of the right arm. And do you want to see the photo? I've got it.
I think we've got it as well.
Right. But in any event, it shows...
I haven't seen it.
Yes. It shows the arm in the air, and that's the one dated 1350. So it's got the metadata of the photograph demonstrates the time as 1315, which is where the 1315 comes from. And indeed, the judge, in summing up, deals with the point, volume 1 at page 44, confirms that was the evidence at 115. You can get that from volume 1, bundle reference, page 44. There's a photograph, his arms in the air. It would have been around 1:15 the following day. And if you break rigour within the period between 2 and 4, then it'll go back to the original position. If you break rigour after 12 hours, then it won't reset. So, my lord, again, that's the basis on which
Thank you.
I understand the timing works. So on any view, Judge of Appeals Isaacs is wrong in paragraph 108 when he says you can take the 16 hours and work it back from the date of finding, from the time of finding. So unless the Judicial Committee want to hear me further on timing of death, date or timing, that's all I propose to say about that. Again, so far as Blue Glass Man is concerned, the position is, I hope, as I've already described, that the prosecution accepted that so far as their scenes of crimes officer was concerned, the scene presented to him demonstrated that there had been 3 people around the table, and he deals with that in the course of his evidence at volume 2 at 358. Where he's referred at 358 to the patio table between lines 7 and 10. He confirms that there are 3 glasses. And on the next page, 359, he's asked about the empty bottles, that's the beer bottles, and asked whether, so far as the glasses are concerned, it indicates, this is line 6, the presence of other persons, or at least 3 other persons. Yes, sir. And did you do any work to determine who the others might have been? Yes, sir, I did. And did you find out who they were? No, sir. And as I've said, the work that in fact was done or carried on in relation to those glasses was their swabbing and the DNA evidence that established who owns them. So I'm not going to take you to Stubbs's evidence about the glasses, but again, you've got the photos. I don't know whether any of the committee have looked at the photos, but you can see the 3 glasses are numbered 4, 7 and 8.
Yes, I think you can take it that we have looked at it.
Yes. And so far as the DNA is concerned, that is dealt with in the DNA statement at volume 4. So the blue glass is numbered 4, and according to the DNA evidence that was read, volume 4, page 904, and so it's item JMS number 4A to B, swabs from the rim of a glass, and that is volume 4, my lords, 904. I think my lady has it electronically. 904 at the bottom of the page, JMS 4A and B, swabs from the rim of the glass, that is the blue glass. And as it says, it's a mixed profile, 2 individuals, the major one a male, excluding all the males who were, from whom samples were provided. Quintana, the house worker, Mitchell Matthew, and Philip Vasyli. And so far as the other glasses are concerned, 8, which is immediately below that, JMS 8, this is the wine glass that's closest to the door, matches Donna Vasyli, the appellant. And 9, again a mixed, this is the wine glass furthest from the door, a mix of 2 individuals. Philip Vasyli cannot be excluded as a contributor to this mixed DNA profile. And then just reading down, because there may be an issue about whether Philip Vasyli was responsible for locking the door, you can see the swabs from inside the door handle and the lock, which are dealt with immediately below that, JMS 15, are Philip Vasyli. So the presence of blue glass man is a point that was specifically raised with the judge at the close of the prosecution case. I don't need your lordships or my lady to look at it, but it is the subject of submission at volume 3, page 688, saying that the jury should not speculate because there were unnamed persons present, because, as he puts it, the DNA evidence shows that there were other persons' DNA found on the glasses on the porch. It's for the prosecution to establish that there was nobody else. That's the submission. And it's simply not dealt with by the judge in his reasoning. His reasoning is in volume 3, beginning at 690, and reading through, but he just simply doesn't address the fact that a case that depends upon there being a single contender as the assailant, the prosecution have not established that fact. And indeed deliberately misunderstand the point that's being made, and perhaps I ought to show you this. The closing speech, which is not perhaps as clear as it might be, deals with the presence of the DNA on the blue glass, and the prosecution deal with it at volume 3, page 771, in a way that I submit is plainly misleading. Nothing else is said about it, other than what's at 771, where you can see DNA, unknown male, it's line 14. Well, only Fred read a portion of the forensic report because he harps on about an unknown male. Well, you know, if you read the whole of the 4th report, the unknown male is explained he left that out. I'll read the entire thing. The DNA profile obtained from this item, referring to MC16, matches the unknown male to Lauren de Graaf, and at the bottom of the page, Lauren de Graaf is the biological mother of the contributor of the major DNA profile. So he says the unknown male, 772 at line 7, is Lauren de Graaf's child. Now, as I pointed out, that is a willful misunderstanding. There were two relevant unknown males, one on the dress, clearly the grandchild, and one on the glass that is unanswered. Indeed, his only comment on the state of affairs as they appeared was to accept that so far as the presence of the beer bottles that had clearly been tidied up and put in the garbage, that was what was to be ascribed to Miles Pritchard, not the suggestion that's now made that it's Miles Pritchard glass. If you go back to 762, he's referring to the evidence of Mr. Stubbs that someone else was there. Do you see that at line 10? The line of questioning I showed you that said there are 3 people there. And he says this, well, yes, other people were there. Other people were there before Miles and his wife left and before Matthew left, leaving the 2 of them home alone. The fact that there are bottles in the garbage, in fact, it's easily explained when you look at the statement of Miles Pritchard, because Miles Pritchard said that he and Mitchell were drinking beers. No mystery about the beer bottles in the photograph.
Did anybody match the DNA on the beer bottles with the glass?
In fact, I'm not sure, somebody may correct me, I'm not sure that the bottles were swabbed.
Okay.
And instead what is said now is effectively that a jury could have concluded as a matter of certainty that the blue glass man was either Miles Pritchard or somebody who'd been there earlier. That's the submission made at paragraph 41 of Mr. Rowe's written case. Whereas the reality is, as the Court of Appeal pointed out, there is simply no evidence of that. Both Judge of Appeal Isaacs and Judge of Appeal Crane Scott said it was simply not appropriate to speculate. And if it's not appropriate to speculate, again, this is not the margins of a case which the judge might want to leave to the jury. It is a case in which the judge would not leave that to the jury, because he'd be bound to say there is no evidence that it's Miles Pritchard or an earlier visitor. That would be his duty, given the state of the evidence. So he's not withdrawing an issue from them. He would simply be directing them as the impropriety of speculation. And the prosecution case effectively does depend upon that speculation being something the jury could do. And in our submission, they plainly can't. Because the reality is that although the Court of Appeal and the judge below dealt with the basis upon which you could assume there'd been no intruder, and we make no complaint about that, it's clear that there was valuable property, there was no signs of forced entry and so on. What they didn't deal with was the possibility of Blue Glass Man being a visitor, and that had to be dealt with. Again, the evidence before the trial court about this estate, it is a massive estate. It's got a mile and a half of beachfront frontage. It's got maybe 100 residences on it. It takes you 20 minutes just to walk from the appellant's house to her daughter's house. So it's well populated by people who will not either go in or out of the front gate. They simply lived there. And the prosecution never dealt with the possibility that there was an additional visitor who destroyed the appellant's the only one with the opportunity case. And the same is true at the point of the locking of the door. The locking of the door only makes sense once it's established that it's Philip Vasyli who locks it, as the DNA establishes. If he's trying to keep out an assailant who doesn't know that you can simply go to the next door along and open it and walk in. So then I'm going to just turn briefly again, I hope, to make sure that I've given the committee the relevant references to the evidence on the picture about blood and the DNA.
But before you start,
Yes, certainly.
Is this something that features in your skeleton, or in your submission, written submission for this hearing?
The blue glass.
No, the argument that it's not identified to be blood that's on the dress, only DNA.
I believe it does.
I've been looking and
All right.
unsuccessfully at the moment. Was it run in the courts below?
I believe it was, yes.
Well, no doubt the reference will be provided.
Yeah.
Thank you.
Yeah. So far as the... but in any event, my lady, the evidence is the evidence.
It might have been one way to have begun my consideration.
Indeed. So far as that's concerned, the evidence about presence of blood is dealt with in a number of points, and I probably can do it most simply from the summing up. So the judge first comes to it in describing wrongly what the evidence was going to be about blood at page 45. So he's summarising the evidence of Inspector King, Volume 1, my lords, 45. This is the summing up. And you'll see the description of cutting out the pieces. And from the DNA report, you'll learn there were small droplets of blood from those cuttings, which proved to be the blood of Philip Vasyli. And obviously that would have been of some significance, because as he points out on the next page, page 46, at line 20, you'll recall Jermaine Knowles, he's a police officer's opinion that the stabbing took place outside. The evidence of Dr. Sands is the knife cut a major blood vessel. It's for you to determine whether it took place outside, but you think because there are specks of blood on the canvas outside, and he's referring also, line 19, to specks of blood on the overhead canvas, that's above the table. And blood below or just beyond the mat, the stabbing took place, and when the artery was punctured, blood went out, up, and in all directions. And then he deals with the blood upstairs, in the summing up, blood in the bathroom, in a face bowl, in the sheet on a mat. But that, he says, is to do with the injury earlier, as it plainly is. Because, as he describes, he was bleeding from a wound on his back. And then that point about a droplet of blood is raised. And so far as the judge is concerned, he then corrects it with the help of the prosecution. And we can pick that up at page 52. So this is in the absence, I'm not sure it's in the absence of the jury, but anyway, it's a correction that's taking place. So page 52, line 27, Mr. Gaskin, Lockhart has raised the issue of the speck of blood being on the dress, and Mr. Gaskin at line 27, who's the prosecutor, says there was no evidence, even as in reference a speck of blood. There was evidence of blood being on the garment, no evidence of a speck or a little bit of anything of that nature. That's the first thing. So in other words, no droplets, no visible blood. And over the page 53, Gaskin again, the prosecutor, Blair's report speaks to finding primate blood. She doesn't talk about the amount. She absolutely never used the word speck. And
where's this all taking us, Miss Montgomery?
my lord, it's taking us firstly to the fact that on the face of it, there is no evidence of visible blood in the face of the judge's own description of blood going up, out, and in all directions.
Yes.
Secondly, he is saying this is the blood. He corrects the fact there's no droplet, but he doesn't correct the fact that it's Philip Vasyli's blood, and I've already made the point that that is not the evidence. Thirdly, he does not explain, back up. He sets out for the jury the fact that blood will not take them anywhere because of the evidence of the earlier injury to Mr. Vasyli's back and the fact that that led to him bleeding and there being blood throughout the house. So as Mr. Justice Isaacs, or Judge of Appeal Isaacs put it, in terms, paragraph 88 of his decision, the possible hypothesis of innocent transfer, even if one got to the point of having Philip Vasyli's blood anywhere on clothing, could not be excluded. And if he's right on that, that's an end of it. In the end, again, this is evidence led by the prosecutor. In order to have any possible sustainable relevance to a decision to convict, you would have to exclude the possibility of innocent transfer. And at least according to his reasoning, he cannot do so. And in my submission, he's right to say so.
Right.
So my submissions to the Court of Appeal, Lady Black asked about the point being raised. My submissions to the point of the Court of Appeal are at page 1429, volume 6. We'll find it in the case, but that's where the point's put to the Court of Appeal. Thank
you. At the top of that page it says there's no evidence from Felicia Blair of blood anywhere than the right sleeve cap.
Yes, they're asking me about the blue dress. Oh, sorry, they're asking me about the multicoloured dress, yeah.
Right.
So if you look over the other page, the prosecutor is saying, oh, but there are two cuttings. And I've said, but the only evidence is on the right sleeve cap rather than the left cutting. And then the DNA evidence was that there was DNA, and I say at 10, indeed, but that was not a finding of blood. DNA comes from your skin, from your hair. If your husband's touched your clothes, his DNA will be on your clothes. Nothing is said about DNA evidence about blood. And that's the point. I mean, it is possible to have DNA evidence that says there is DNA and it is DNA from blood. That is within the expertise of a DNA specialist if they have a sufficiently good sample. But as the DNA primer makes clear, and this may actually finally lead me to break my promise of handing up the additional bundle, the DNA primer makes clear that that is a separate piece of investigation that has to be carried out, because otherwise it's impossible to tell just from DNA what the source of it was. So I am going to break that promise. Would your Lordship's mind looking at that supplemental volume just for the purpose of looking at the DNA primer?
Yes, well, we have this for those who are working electronically, in electronic form.
Oh, fine, then it's page 1895.
Well, I don't think it's been added to the e-bundle, but anyway, let's proceed with dispatch through this.
Certainly, my lord. So,
Forgive me, the reference to the right sleeve cap is reference to the floral dress or the blue dress?
floor dress.
Thank you.
Right.
So, my lords, my lady, this is a primer produced in association with Judicial Studies Board and the Royal Society because of concerns expressed about misunderstandings about DNA, and I'm just going to deal with this point about source of the DNA. And it's dealt with at 1895, my lord, my lady.
Which is what page of the internal page of
Internally 46.
Sorry, 46?
46, yeah.
Yes.
So, dealing with DNA transfer, the end of the first paragraph, transfer events require three things to be considered: source, opportunity, and mechanism. The first consideration is whether or not it's possible to attribute the DNA profile to a particular body fluid. It might be possible to say it comes from blood, semen, or saliva. There are tests, they say. However, at the end of that paragraph, they point out there are occasions when a forensic scientist will be unable to give an opinion on body fluid of origin. And they make the point that it can come from touch. Once DNA is transferred by touch rather than a specific body fluid, this is known as touch DNA. DNA can persist for many months on an item, and determining when it was deposited is not possible. And then you have to consider variability, intensity of contact, nature of the surfaces. And as they say at Internal 48, 1897, questions about how long after a transfer occurs as to how long DNA can be recovered or how it can be transferred are currently unknown. And you can see the summary. It's not possible to determine when DNA is deposited. It can persist for many months. Secondary or tertiary transfer can occur. With every transfer, you expect a loss of available DNA, but the quality will not rule out a particular type of transfer. So the short answer is
yes.
The DNA evidence did not provide any particular information about the source, and therefore, as I explained in that submission we just looked at, it could as easily be touch DNA. In fact, most probably would be touch DNA, whether primary or secondary or tertiary transfer, given that, on any view, Philip Vasyli lived in the same household as the appellant at this time. So just to complete the evidence, to give the references to the DNA evidence again, I think I took Lady Black to the first report of the DNA findings, there, which is looking at the sample 1, sample 2 that we looked at, which was at 908. It's then resubmitted for the purposes of further analysis, volume 4 at 920. So this is the second DNA report. (920), volume 4. And this is now looking at the whole dress. So MC 16B, multicoloured dress. And you can see a page before that's been delivered as a whole piece at 919. And so now the dress is revealing a three-way DNA trace. The major DNA profile, unknown male. The minor DNA profile, inconclusive. So it is resubmitted again. This is the third DNA report at 925. This time, this is the Y DNA being analysed. And as the committee will appreciate, certainly if you've read the primer, this is a much less selective but exclusively male DNA test that allows you to discriminate between men, not to the point of 1 in a million, but sometimes 1 in 1,000, 1 in 10,000, and so on. And so it's looking at the male DNA profiles on the dress at 925, and you can see it says there are 2 male profiles, 1 major, 1 minor. The minor DNA profile, in other words, the one that's giving you less of a reading, is from Philip Vasyli, which says that the frequency of that profile is 1 in 8,600. So it's not particularly discriminating, but it does suggest that it matches his Y DNA. And then it is analysed for a 4th time at 929. This time, again, a full DNA test, not just the male DNA, and the results are at 929. And this is now from a number of samples from the multicoloured dress, floral dress, back collar, back waist, front bottom, back bottom. And as you'll see, there are probably at least 5 DNA traces. So the back collar has 2. 1 is an unknown male. A minor DNA is inconclusive. And the back collar trace is the one that looks like it comes from the appellant's grandson, because of what follows. Lauren de Graaf cannot be excluded as the biological mother. So this is the point that the prosecution picked up and tried to explain away Blue Glass Man. This unknown male is indeed most likely the grandchild. The odds are 626 times more likely that she is the mother. Then the back waist has 3 DNA profiles with 1 male contributor who can't be identified. And then the bottom has another 3, major profile for Donna Vasyli, and minor profiles inconclusive. So far as the blue dress is concerned, I showed you the finding on the blue dress at 908, and then it was resubmitted again at 919. Again, as a Y DNA analysis. Bottom of that page. Two profiles, a major and a minor Y, so 2 males, and the major Y DNA profile matching Philip Vasyli. So I regret to say that my submission is, having gone into that detail, that the evidence in relation to the blood and the DNA is utterly meaningless. It can have no weight and certainly cannot contribute to any case to answer.
Right. Well, in summary, you say this should be left severely out of account in assessing whether there's any prospect of conviction.
Yes.
Right.
And so one is then left with, at most, an equivocal statement in circumstances where the time of death, the evidence of the time of death and the opportunity simply doesn't establish the necessary fact. The necessary fact that has to be proved for a jury to have this left to them is that she is there when he dies, and she's the only one there when he dies. Now, if the committee is not with me on that, this is, in our respectful submission, a case that should obviously go back to the Court of Appeal so that they can understand the answers to all the questions Lord Kerr has asked me, which I've not been able to answer, quite apart from the fact that, in addition, as Mr. Rowe accepts, there may have to be some consideration given to the prejudicial publicity that's happened in the meanwhile, particularly as I can tell you, without going into the detail of that publicity, it relates to evidence.
Before my learned friend says anything further on that subject, I would respectfully invite that.
You will have seen what Mr. Rowe says about it.
I have, and I'm not going to say anything that might invite any inquiry or enable anyone to make an inquiry. We asked the
take it that we're aware of it. We're aware of what has been said about it, and lest there be any even remote risk that you're dilating further upon it could give rise to a problem, it might be better to refrain.
My Lord, I'm grateful I will do so. We, in fact, asked the attorney to take steps to prevent it, but he chose not to.
Right.
All I need to say is your committee does have in the bundle at volume 2, page 277, the judge's ruling on the admissibility of that material, making it clear that it was not admissible.
Right.
And should not have been published.
Right.
And should have been restrained, as we asked.
I think we're all conscious of that. Thank you very much.
Content to leave it there. So I hope our position is clear. This is not a case that was made out on the evidence, not equivocal evidence, not matters on which the jury were entitled to reach a conclusion, matters that required them to speculate in a way that was utterly impermissible and should have been prevented by taking the case away from them. If you're against me on that, on any view, this is a weak case that will require detailed consideration of the sort that Lord Steyn identified in his judgment dissenting in Phillips. Can I assist any member?
Thank you very much indeed, Mr. Montgomery. Very, very helpful. Thank you. Ms. Buckley? Mr. Rowe.
My Lord, my learned friend and I, thinking about the organisation of the room, have decided to pretend that we're back in number 9. Speak from the middle, so...
I was going to say it's a reversion to the appellate committee, isn't it,
take
Mr.
a
Rowe?
moment to...
With a short walk.
That leaves me free to get to everything I need to get to. My Lord, to start with, if I may just deal with this question of the blood transfer. I'll come on in a moment to outline my submissions as a whole, but I do want to just put down a marker in relation to this point about the blood. My learned friend was asked by Lady Black about whether this was a point that had appeared in the printed case. It does not appear in the printed case. In fact, it is contradicted by the printed case on the part of the appellant. Can I just take your lordships to that and then come on to say what I want to say about how, in my submission, this should be dealt with. If your lordship has the appellant's written case, which in the electronic version is at page 1664, or your lordship may have it separately, we can see at paragraph 44, which is 1676, what is said about sufficiency of evidence. And at 44 it explains that the Court of Appeal dealt with that to some extent, and at 45 my learned friends say the weaknesses in the prosecution's case and which were the subject of the appeal hearing included, and the first one is the DNA evidence, blue glass man. The second one is the pathologist, the point about the timing. The third one is this: the fact that an innocent blood transfer could not be discounted to explain the presence of Philip Vasyli's blood on the blue dress worn by Ms. Vasyli on the morning of 24th of March 2015, and on a multicoloured dress which was found in the room where Ms. Vasyli had spent the night. Blood evidence. And then there's explanation as to why it's said that an innocent blood transfer cannot be discounted. The suggestion that that actually there's no basis for thinking this is his blood at all, is a suggestion made certainly in this appeal. I'll have to go back and recheck what was said in the Court of Appeal, which I must say, having read it, I can't recall it, but I'm happy to be, if I may, given a moment to look at it in due course. But certainly as far as these proceedings are concerned before your Lordship's board, this is the first time this point has been made. And my Lord, in those circumstances, I would respectfully not wish to be limited in my response to it, if your Lordships are prepared to entertain it, simply to what I can come up with in the time I've got available, as it were, on the hoof. And I would wish...
Well, we're not going to give any preemptive decision on that.
No,
Mr. Rowe.
I wouldn't expect your Lordship to, but...
You've got to do your best in those circumstances.
I will do my best. All I'm coming to is that I might, at some convenient moment, depending on how everything else emerges in the argument, invite your Lordship to give me the opportunity to put a short written submission in that deals with the detailed reference to the particular documents and exactly what you can take from them that my learned friend relies upon, particularly as the written documents include the DNA primer, which was served on those instructing me a week ago. But, my Lord, that's the extent of my protest about that. Right. But I certainly don't ask your Lordships to rule on the question here and now. Right. So, my Lord, in the time before the short adjournment, it might be convenient if I just set out in broad terms the way in which we respectfully invite the Board to deal with the matter. We accept, and I should say I'm following broadly the scheme of our printed case, we accept that the way in which the Court of Appeal dealt with the issue of whether to order a retrial went wrong.
Yes.
And we say that because the Court of Appeal did not give the appellant an opportunity to make any submissions as to whether a retrial was appropriate in the light of its disposal of the appeal, and because, although at a stretch you might say that the President, if implicitly adopted Justice of Appeal Isaac's reasoning that there was a case to answer, we accept that on the face of it, her judgment doesn't say that, and says she's going to make no pronouncement on the issue, which we accept is not really sufficient in circumstances where the appellant was saying there is no case to answer. So it was unsatisfactory to order a retrial in those circumstances. There's been criticism of the respondent for, I think it was said, having led to the situation where here we are in 2020, arguing the matter before your Lordship's board. The reason we are here arguing the matter before your Lordship's board is because the appellant wishes to and has today asked your Lordship's board to say there shall be no retrial because of the insufficiency of the evidence. That's why we're here. There hasn't, as far as I'm aware, there hasn't been a suggestion previously even floated as a possibility or impliedly floated as a possibility, as I think was being done earlier, that really this whole thing could go off to the Court of Appeal so that they could decide whether the no case point is a good one or not and look at all the other factors. The reason we're here is because...
you argue that it shouldn't go in the circumstances back to the Court of Appeal, but do I gather from what you've just said that had the appellant at an earlier stage suggested that the Court of Appeal be required or invited to reconsider it, that respondent would have acceded to that?
I couldn't go as far as that, my Lord. I don't know. I don't have instructions that would enable me to answer that question confidently. Yeah, well, either way, in those
circumstances, you can't attribute entire blame to the appellant.
I don't think I was trying to. My Lord. I was responding to the contrary suggestion that the entire blame lay on our side. Right. But so far as our position before the board now is concerned, the appellant, as my learned friend makes clear, says your Lordship should say there was no case to answer. Yeah. And we accept that if your Lordships are persuaded of that, then we can't ask for a retrial of a case where there was no case to answer. That I submit is what's meant in the Reed case about the prosecution curing deficiencies in its case. If there are deficiencies such that there was actually no case to answer, the point that's made in the Reed case is that you can't have endless retrials with the prosecution having another go to see whether it can get a case off the ground that is actually a case to answer. It's different in my submission where there is a case to answer. So we respond to that submission by the appellant by saying, no, your Lordship should reject it. And my primary submission is the Lordship, having heard the submission, should reject it on the merits and say there was a case to answer, and then go on to consider further points as to whether, in those circumstances, the Court of Appeal's order for a retrial should simply be endorsed. As a matter of formality, there is an order for a retrial, and this is an appeal against it. So as a matter of formality, it would be a matter of saying appeal dismissed. The order for a retrial stands, but I accept that because of the reasoning of the Court of Appeal and the deficiencies in it that we've identified and accepted, the board would need a little more, at least do a little more than that. So that's my primary case. The alternative position, I suppose, which neither of us has expressly canvassed, but which must theoretically be there, is that your lordships might say this is all very interesting, the stuff about whether there's no case to answer or not, but even that should go to the Court of Appeal. In other words, the proposition that your lordship has just mentioned. For our part, we are content now that the matter is before the board, that the board should deal with the issue, but there is of course the possibility that the lordships may simply say it's a matter for the Court of Appeal. In any event, if it is a matter for the Court of Appeal, then we do respectfully submit that the board ought to give a pretty firm indication that any consideration by the Court of Appeal of the possibility of a retrial should be done as quickly as it can be done, because we're already approaching the 5th anniversary of this offence. So that's our position in relation to the appellant's primary submission. If we are right that there was a case to answer, and your lordships conclude that there was a case to answer, then we say really there's no advantage in remitting to the Court of Appeal the question of whether, there being a case to answer, there should be a retrial. The Court of Appeal has already considered that question by reference to the right authority, Reed. It is true, of course, that the Court of Appeal did not have the benefit of any submissions from the appellant before doing that, and so everything that it said needs to be considered quite cautiously. But nevertheless, we submit the Court of Appeal did correctly direct itself as to the appropriate law. It decided that the public interest in the Bahamas in having this very serious matter retried was such that there should be a retrial. And really it's not for, we would say respectfully, for the board to say, well, that needs to be looked at again by the Court of Appeal. If there are specific concerns about a fair trial, whether that's possible, then that is a matter for the trial judge.
Given that, as you correctly, in my view, accept that the Court of Appeal should have allowed the appellant to make submissions, can we avoid remitting it to the Court of Appeal unless we are satisfied that the Court of Appeal, had they received submissions, is bound to have decided that a retrial should be ordered?
Yes, because your lordships can take account of the fact that the appellant has the opportunity to make submissions before the board, but has decided to take the position that this is all a matter of the Court of Appeal. And I quite accept that the failure of the Court of Appeal to entertain submissions about the question of a retrial means that the weight I can put on their decision to order a retrial, let it be assumed that there is a case to answer, is much more limited than it would be if they had actually done the right thing and heard submissions on the question. It doesn't go quite as far. It doesn't.
Ways of looking at this. Either we can say, well, the Court of Appeal didn't entertain submissions on it, and therefore we can't speculate as to how they would have decided it, and therefore we ought to remit it to the Court of Appeal so that they can hear submissions on it. Alternatively, we might say, well, possibly three possibilities, but alternatively, we can say, well, we, having had the benefit of submissions on it, decide of our own initiative that there should be a retrial, and therefore it's not incumbent on us to send it back to the Court of Appeal. And therefore we don't need to address the question, what would the Court of Appeal have done, which I suppose is the third possibility. So the second of those suggestions may be a via media between the two extremes. On the one hand, it's got to go back to the Court of Appeal because they didn't hear submissions, and on the other hand, the Court of Appeal is bound to have reached this decision. Do you invite us to choose the second possibility that I've adumbrated, namely that we can, of our own initiative, decide that there was sufficient here to order a retrial?
Well, my lord, essentially, I suppose broadly I do, because the way I put it is to say this: if we get to the stage of deciding that there is a case to answer, then the question does become whether the public interest in the Bahamas justifies there being a retrial, and either as part of that or I suppose as a separate consideration, is there any specific reason why there shouldn't be a retrial? I mean, I accept theoretically questions like prejudice might as well be dealt with by the Court of Appeal. If at the moment that a retrial is being considered, it's obvious that a fair trial isn't possible, then it would be silly for the Court of Appeal to say, well, that's a matter for the trial judge, if the Court of Appeal could see it plainly. But the position we have here is that the Court of Appeal directed itself in accordance with Reed and determined that what was appropriate in the public interest in the Bahamas was a retrial. And the appellant complains, well, I didn't get an opportunity to address the Court of Appeal on that, and we accept that's a fair point. The appellant should have been given an opportunity to address the court on that. But the appellant doesn't say, if I had been given the opportunity, I would have said X, Y, and Z, and that would have made all the difference. Because the reality of it, in my respectful submission, is fairly plain. This was a very serious offence, relatively recent in the scale of how long criminal proceedings take to come on, especially in this part of the world. And on the face of it, if there's a case to answer, then the fact that the judge misdirected the jury on, in fact, only one point. I've identified this in our printed case. The only point upon which the Court of Appeal one can discern any consensus in the Court of Appeal about the judge getting it wrong is the Lucas direction. The fact that the judge made a technical error in the summing up to the jury it means the conviction has to be set aside, but all other indications point to there being a retrial. And as I say, it might be different if the appellant was coming along saying, well, actually, there's this compelling public interest factor which I wasn't given a chance to address. But my learned friend's case is essentially an abstract one. Say, in principle, I wasn't given this opportunity, and therefore I should be given another opportunity. And essentially, I think my learned friend's submission comes to this, that I don't need to identify before the board the factors that I would put before the Court of Appeal. Beyond what I accept my learned friend's done in terms of saying, well, what about the prosecution improving its case? But, my lord, that's a point that cuts both ways. A retrial is impermissible where the improving of the case consists of turning a hopeless case and a no case to answer, no prima facie case, into a case to answer. But leaving that situation aside, the possibility of improving the evidence is, of course, a risk that you take when you order a retrial, but it cuts both ways. The defence could improve its evidence too. It could take different decisions about how to run the trial. That's just one of those things that inevitably happens when there's a retrial. So, my lord, I hope that broadly answers what we say the board ought to have done. So can I turn then to the question of whether the appellant is right to say that there was no case to answer. Effectively, what's said is the Court of Appeal ought to have accepted her ground too of her appeal, which was essentially that there was no case to answer. My lord, the overarching fallacy, the underlying fallacy, I should say more accurately, more appropriately, of the appellant's submission, I submit, is that in order for a circumstantial evidence case to succeed, you need to show essentially that all of the physical evidence is, as a matter of physics, only consistent with the prosecution's case. That theme runs throughout the appellant's case, in my respectful submission. It said, well, you can't physically exclude the possibility of things happening in a different way from the way the prosecution puts things. Therefore, there was no case to answer. That in my submission, is not the right approach. The question is simply whether the case was safe to be left to the jury, and you answer that by saying, could a reasonable jury reasonably have reached the conclusion that this case, on this evidence, if unanswered, led them to feel sure that the defendant was guilty of the offence charged? And we respectfully submit that the answer to that is yes. My lord, it might be convenient if your lordships have our written case to hand to have it out, because I'm going to follow broadly the scheme that's set out there. And I'm picking it up, if I may, at paragraph 20, which is on page 1689.
Yes.
I set out there essentially what I've just said, and we come on then at 22 to facts which I say were all either undisputed or capable of being accepted by a reasonable jury. It's one thing to go through, as my learned friend did, picking out particular bits of the evidence and criticising this and criticising that, but in my submission it's quite important to look through the whole of the evidence that was before the jury. And I would respectfully invite your lordships insofar as the opportunity may not yet have arisen at some convenient moment to do the exercise and be reading through the whole of the trial, because it's quite difficult to assess in the round whether there was a case to answer without having that feel that one gets from the whole of the evidence. But starting at 23, we make the point about the length of the appellant and Mr. Vasyli's marriage. I think that's a paragraph where for some reason the numbers have gone a bit wrong. The figure at 22 should actually, I think, be 34. And the reference, for reasons I don't know, has gone wrong, but it should be 838, not 842. And you can see that I appreciate these are perhaps sort of obvious points, but they lived together in a house in a gated community. No one else lived with them. There was some evidence, and I want to, as I go through, just expand and from time to time insert, if I may, other references into this. There was quite a bit of evidence about security at the gated community. And can I just invite your lordships to pick that up in volume 2, page 223. This is in the evidence of Cassius Powell, who, as he explains at line 15, was the assistant head of security at the community. He explains what's meant by a gated community. At 22, community built for residents of the island has its own 24-hour security. We said it's gated. Yes, sir, persons are generally able to access that area, sir? No, sir, not without a resident's permission. Is there any other way to access the area other than through the gate, sir? And he says over the page, yes, we have a canalway. We also have a beachfront. And is access through the canalway generally available? No. A resident would have to inform us that they're expecting someone, and we have a chain-link fence to bar our canalway. And what about on the beach side? What we have is most of the properties are privately owned. We normally have 2 security officers on the beach. But if someone does come past a certain point, I believe it's 2 feet above the shore, that would be trespassing. You said there were 2 persons on the beach. Yes. Is that at all times? No. From 6 p.m. to 6 a.m. And that's every night. Yes, every night. Going on a bit then, if we pick it up at page 226, in the middle of the page is the evidence. It's only a guess, but it's probably broadly right about the length of the beachfront, line 17, 1.5 miles long. If we then go, my lord, to page 375, there's some more evidence which is relevant to this issue. We're now in the evidence of Marvin Brown.
Sorry,
375, my lord.
thank you.
We're now in the evidence of Marvin Brown. That evidence had started, if you want to note it, at page 371. And he talks about the patrol on the beach, line 7, 6 checkpoints on the beach. We call it CP. We swipe them every 20 minutes. You say you swipe them. It's a machine you hold and you swipe it every 20 minutes. Seems to be a sort of system that ensures that the people on patrol have to prove that they're moving between different points. And further down he says there are 2 persons, line 17, 18, they're always together. Yes, sir, and he repeats the point about the beachfront being about 1.5 miles. Over the page, he is asked about reports of break-ins. Line 3, he says in the 6, this is 376. In the 6 years you've worked there, have you had many reports of break-ins? No. Received reports of break-ins? No. So that gives something of the flavour of the nature of the property. There are a few more references, but I noticed the time. I think perhaps it might be convenient if I pick this up at 2 o'clock.
Yes. Very good. Right, I'll sit again at 2 o'clock. Okay.